The Fourth U.S. Circuit Court of Appeals recently ruled in a lawsuit challenging the dress code of a Brunswick County charter school. The case could have larger implications for other charter schools in North Carolina, and joining us to explain why is Jeanette Doran, President and General Counsel of the North Carolina Institute for Constitutional Law. We're going to get into, Jeanette, why this could have implications for all charter schools. But first of all, this is a case dealing with a dress code. Female students in the school had to wear skirts, and there was an argument made against that dress code on at least a couple of different grounds, and the Court of Appeals ruled in two different ways.
They did. The plaintiffs brought a lawsuit, and they had really a handful of different issues, but there were two claims that went up to the Fourth Circuit. One was an equal protection claim, brought under a federal statute called 1983, and the other was a Title IX claim, which most people have heard of Title IX, but they've heard of it in the context of sports programs, particularly at high schools and colleges, but it has a broader application. So those were the two big issues at the court.
Now, when this initially went to trial, if I understand correctly, the charter school lost on the issue of the first claim, but won on the issue of the Title IX claim, and then the Fourth U.S. Circuit Court of Appeals reversed it.
Well, when I was at the trial level, and there wasn't a trial, the case went before the district court, U.S. District Court, on what are called summary judgment motions, where each of the parties asked to win without having to go through a trial. And what the district court said is that the uniform policy was not covered by Title IX. And so the district court disposed of the Title IX on that. But on the 1983, the district court said basically that the plaintiffs could pursue that equal protection claim. When it got to the Fourth Circuit, the Court of Appeals basically flipped on that. So the Court of Appeals said the 1983 claim for an equal protection violation, that couldn't provide relief. The defendants weren't state actors, and so the plaintiffs lost on that. But it remanded, meaning sent back to the trial court, the Title IX case. So just the opposite of what the district court had done.
Now, barring any future appeals, then this case is still active, and potentially the charter school could face some problems under Title IX. But moving forward, the issue that we talked about first, the Section 1983, the equal protection, you have focused in on that as something that could be of great interest to all charter schools moving forward. Why so?
Well, the way, and I think the court did a really good job of laying this out. So the Equal Protection Clause and the federal statute, the 1983 statute that allows people to sue for violations of their federal rights, only applies to the government. It doesn't apply to private actors. So in this case, the charter school is a private corporation. It's a nonprofit, but it's a private corporation. And there is some risk for private entities, private actors, to be held responsible under 1983, but only if what that private entity is doing can be fairly attributable to the state. This case is significant because the Fourth Circuit determined that this charter school, when it adopted the uniform policy, was not acting as the state. It was acting as a private actor. And if we had had a different kind of decision come down, it could have had catastrophic consequences for other charter schools, because other charter schools could have looked at their own policies and their own programming and thought, maybe we shouldn't do that just in case we get sued, just in case somebody comes along and claims an equal protection violation. And that would really subvert the purpose of the charter school program.
This case dealt with a dress code, but the analysis used in this case could be applied to other challenges against charter schools?
I think the rubric set forth by the court in evaluating whether charter day school was in fact a state actor or not in fact a state actor, that general analytical framework will be used in subsequent cases, and I think it will also deter frivolous lawsuits.
Is this the type of thing that, beyond the particulars of this case, could end up being good news for charter schools legally going forward into the future?
I think so, and I think there are probably a fair number of charter school advocates out there. Certainly their attorneys are probably breathing a sigh of relief that they aren't going to be subject to lawsuit after lawsuit from various students and parents and anti-school choice advocates who want to manipulate the laws and attack charter schools sort of through the back door.
As this case moves forward, and if any other similar cases move forward, we know that one person who will be watching very closely is Jeanette Doran. She is president and general counsel of the North Carolina Institute for Constitutional Law. Thanks so much.
Thank you, Mitch.